Hi, and welcome to Industry Insights, live from the Heckerling Conference. My name is David Lennick, and I'm the Associate Legal Editor at Trust and Estates Magazine. Joining me today is Marty Shenkman. He's an attorney in private practice in Paramus, New Jersey and New York, and a frequent contributor to Trust and Estates Magazine. Welcome, Marty.
Thank you.
You know, a big issue today seems to be planning for estates under 10 million. How are you handling that?
Let's first define the parameters. And for those watching this, it's an incredible amount of noise and action in the background, so I hope it all comes through clearly. The 10 million is the exemption amount that's available for a married couple. 5,340,000 this year, it's almost 10.7. So the idea of under 10 million, what are you doing to plan for? What are we doing to plan for as an industry, clients under the federal exemption amount? And from a planning perspective, and I'm sure this has been addressed by lots of speakers, but it's what everybody's talking about, has to refocus on, is income tax is the new estate tax. So for people that aren't facing a federal estate tax, maximizing basis, addressing income tax planning issues is something that's critical. And we'll talk about how that affects drafting and planning in a minute. But the income tax basis issue is just one component of it. There's still about 20 states that have decoupled from the federal estate tax system. So for many clients, addressing estate taxes on a state level is critical. So that has to be addressed in the context of the offsetting of a loss of basis and in the context of making things cost effective when there's not a federal estate tax savings as well. New York, just in the last week, I believe, proposed changing its exemption and potentially reinstating a gift tax. So it's quite a moving target. And one of the other pieces that makes it very challenging is when you're planning for a client today, where might they live down the road? So how far do you go to save a state estate tax if they may not be in the same place? There's another whole broad area for the under 10 million approximate client, and for an individual it may be under 5 million or so, and that's what I call repurposing. So many of these clients over the years have put in place a whole range of planning, family partnerships, limited liability companies, insurance trusts. What do we do to take that planning and not just unravel it, but repurpose it so it works in the new environment? And that's going to be a fascinating new area of planning for all of us, and hopefully something that will generate a lot of work and a lot of benefit to clients. And by the way, I think that repurposing is the approach we want to take, rather than saying to a client, gee, that partnership you spent all the money on, we're not going to just dissolve it. I don't think that's the approach.
You mentioned drafting. What are the effects on that area?
The wind from the door?
Yes.
No,
exactly.
The drafting. Bad humor. Estate planning humor, I tried. Drafting will change in a number of ways, not fundamental, profound ways from major bills in the past, but I'm sure many of you have already heard, but when you're drafting a trust, you now need to consider the compressed tax rates at 3.8% Medicare tax. What do you do to draft a trust to address basis issues? So some of the things that people are looking at is giving the trustee greater flexibility to distribute out capital gains, so it's included in trust accounting income, so that you can make a distribution to a beneficiary in a lower bracket and avoid the higher tax on the capital gain inside the trust, because generally, historically speaking, the capital gain would have been trapped as part of corpus in the trust. To get basis, some practitioners think that in general, the broad distribution provisions they've commonly used are enough to shift out to a beneficiary an appreciated asset so you can get a basis step up. Others are not as satisfied and are reconfiguring some of their distribution provisions so you can flow out money consisting of an appreciated asset to get a basis step up. The counter to that is you got to be very mindful what you're doing. So if you're flowing out an appreciated asset and gee, you may get a basis step up, but the new spouse or whatever ends up with the money, you've really done great harm to the family. So the tax planning tail really can't wag that dog, because that's going to be quite problematic. From a drafting perspective, one of the things that I see happening is, and I made a name up for it, a MILET, because I'd never made up a name for a trust before, multi-purpose ILET. Clients under the federal exemption amount are looking for things that are more simple, that are less costly, and more versatile. So in the past, we may have done an insurance trust for a client. We may have done perhaps an asset protection trust of some sort, another irrevocable trust, like even a trust for grandchildren to pay for education. We have a bypass trust and so on. It may be feasible to recraft the basic insurance trust into a more multi-purpose trust that serves the purpose of a SLAT, a spousal lifetime access trust. So it's an asset protection trust, and the spouse can benefit while you're alive. It can hold insurance so it serves the purpose of an insurance trust. And if you already shifted assets out of your estate, you may have created the state estate tax savings in any state right now, because New York may change, other than Connecticut and Minnesota that don't have a state estate tax. So you serve that purpose. And if you've already avoided the state estate tax or minimized it and used up a good chunk of your exemption, you may not need the bypass trust that has been perhaps the most common thing to include in a will from trust planning. So if you use a more multi-purpose flexible trust, you may be able to do less planning for less cost and keep these clients under the 10 million threshold happier.
Keeping account of all the things you just talked about, how do you see that all affecting your practice?
I think it affects not just my practice, but I think over the next coming years it's going to have a profound impact on how everybody practices. I think that the drafting of legal documents is becoming more commoditized. Clients, I don't believe this at all, that we're losing clients to LegalZoom. I don't think that's at all in the realm. But I think the mindset that, with computerization things should be cheaper and more efficient has taken hold, and I think clients are getting more demanding. So in order to be more efficient, especially now that there's not, gee, I'm going to save you 50% of your estate tax benefit, we need to be more efficient. So document generation, the paperless office, all those things that can bring efficiencies, new practice management approaches that will save time and cut drafting costs, I think that's all going to be something that even if we could have ignored it in the past, we're not going to be able to. And with that, billing changes are going to have to occur. So if you become more efficient, what are you going to do? Bill less than you did 10 years ago and not be profitable? That doesn't make sense either. So I think a lot of the alternative billing that many of us, including me, tried to ignore for most of my career, I think we now have to deal with it. So I think they're exciting times. I think that we all can be as busier than ever, but I think it's going to be different. I think the traditional role of an estate planner being a family counselor and advisor is going to become more paramount than being a creator of tax benefits, which is kind of what many of us had to focus on because that's what clients wanted. So I think it's an interesting time, but different.
Thanks so much for your insight, Marty.
Thank you.
For more information, visit wealthmanagement.com.